Corporate restructuring practice involves working with companies that are in financial distress. The practice area can be called bankruptcy, insolvency, creditors' rights, business finance and restructuring, or the like. It's often referred to as the last generalist area because it involves so many different practice areas, industries, and types of law. A restructuring group may stand alone, or it may be housed within another practice at a law firm, like the litigation or corporate finance groups. This isn't surprising because restructuring work can include both deal work and litigation practice. The type of work a restructuring lawyer does varies and is influenced by a few important factors. Who your firm represents, for example, the company or its creditors. Whether the matter is in court or out of court, and whether the company is reorganizing or liquidating. Law firms typically specialize in either debtor or creditor side work, though many firms represent both. And a firm can also represent other players in a restructuring. Debtor side representation is like being the general counsel of a company in distress. A debtor's lawyer needs to be aware of every aspect of the company's operations to fully understand the consequences of a restructuring. These lawyers ask questions like, does the company have affiliates or subsidiaries with independent boards that each require their own counsel and advisors in a Chapter 11 process? Is the company publicly or privately held? There are different shareholder considerations and reporting requirements depending on the answer. And does the company's industry affect the strategy and possible outcomes of a restructuring? Creditor side representation varies depending on the type of creditor your firm represents. For example, your client may be a secured lender, like a bank, an unsecured creditor, such as a bondholder or a trade vendor, a utility company, class action plaintiffs, an official or ad hoc creditors committee, or a key employee. A creditor's lawyer needs to understand the nature of the creditor's relationship with the company and the creditor's ultimate strategic goal. Is it about getting paid, reducing risk, becoming the owner of the company after a restructuring transaction? The answers to these questions will determine the legal team's advice and plan of action. Third-party representation also varies greatly. Typical third-party clients include individual board members, distressed debt investors, or potential buyers of the company or its assets. Here, the lawyer may be focused on reducing potential risk to their client in the bankruptcy, like by getting third-party releases under a Chapter 11 plan. Or the focus may be on conducting diligence on a debtor and ensuring compliance with bid procedures for the client's participation in a 363 sale. There are two types of matters in restructuring work, in-court and out-of-court. In-court corporate restructurings are done under Chapter 11 of the U.S. Bankruptcy Code. Debtor counsel works with the company to create a plan to reorganize its finances or operations so the company can continue to operate or sell itself as a going concern. Representatives of the creditors, on the other hand, work to protect creditor claims and maximize the value of the company's assets so that the creditors receive as much as possible in the case. For both sides, the work is largely litigation-based. It's a lot of drafting motions and orders, attending and arguing at hearings, and negotiating the terms of orders and settlements. There's some deal work in there too, related to things like asset sales, DIP financings, use of cash collateral, or the resolution of in-court litigation. Out-of-court transactions are usually consensual deals between a company and some or all of its creditors. These deals amend, extend, or otherwise alter the company's debt without having to overhaul business operations. The work generally includes negotiating, drafting, and executing deal documents, like exchange offers, distressed asset sales, or amendments to credit agreements. Whether a distressed company chooses reorganization or liquidation as its path forward has a big impact on the lawyer's work. A distressed company usually has three main options: to liquidate and go out of business, to be sold to a third party and continue in business under new management, or to reorganize its finances and operations and continue the business with a fresh start. Each path requires different things from the party's lawyers. For example, If a company decides to liquidate and go out of business, its lawyers may help the company sell its remaining assets and pay off outstanding debt without going to court. If the company will be sold and continue under new management, the lawyers might negotiate an acquisition transaction. Or, a company could reorganize under Chapter 11, and its lawyers would represent the company throughout the case. Typically, sales to third parties and reorganizations are at the core of restructuring work at large firms.